Good evening, everybody.
Good evening, sir.
Good.
Good evening to all of you.
All right. Good.
Yesterday we just started the civil procedure code.
So, give a disclaimer. If you reply on mother disconnect the Google link, we'll connect back through phone. I'll get. If the class get disconnected, don't get worried. There's a thunderstorm going outside. In case if the class get disconnected, we'll connect again. Stay tuned on the same ID. All right. Thank you.
So yesterday we just started the civil procedure code. I gave you a brief history of frame of suit, joinder of parties and joinder of parties and joinder of causes of action, and effect of consequences of misjoinder and non-joinder of parties and misjoinder and non-joinder of causes of action. Then we also went through the summons procedure under Order 5. What are the different types of summons and how the amendment has taken place. Now, what you can do for speeding up the case. Then we also said after the summons are served, the party appears either personally or through his advocate or through an agent duly authorized to represent him, and then the advocate who appears for the party files a document called a wakalatnama, where the advocate acts as the agent of the party, and then he files the wakalatnama into the court. Then after that, the next stage we discussed yesterday was rules of pleadings as laid down in Order 6. First and foremost is that all plaints will have to be filed in A4 size and in duplicate, and one more copy has to be given for scanning for the computer, and then it has to be properly stitched and filed into the court. Then the second rule which I discussed yesterday was Order 6 Rule 2, which says plead and then prove. No question of proof and without pleading. So pleading plays a very important part in a civil litigation. The question is what all you want to state, you have to state it in black and white. You cannot take the other side by surprise. So the other side must be able to answer what all allegations are made by you in the plaint. That is the reason it is said plead and then prove. Without a pleading, there cannot be proof, or no amount of evidence without a pleading will take you anywhere. This is what all we have done yesterday. Then we go to Order 6, Rule 4. Sometimes what happens is, to prepare a written statement, some of the averments that are made in the plaint are not clear and clear. In that case, you can file a petition before the court and say, sir, please direct the plaintiff to clarify these positions so that I can prepare the written statement. Once such a petition is filed under Order 6, Rule 4, it is incumbent on the part of the plaintiff to explain each and every query that has been raised in the Order 6 Rule 4 petition. That is what is called petition for better particulars. That is Order 6 Rule 4. Then we go to what is called variance between pleading and proof. That's what I said, plead and then prove. Suppose you don't plead a particular aspect and your evidence which you lead, whether it is oral or so on and so forth, it is quite inconsistent with the pleading which you have made. Court will not allow you to lead that evidence, and even if that evidence is led, it will not be believed or trusted by the court. That's why it is said variance between pleading and proof. Then another important rule which is very, very important is Order 6, Rule 17. Okay, here, suppose let us say sometimes certain subsequent events happen which has got a material bearing on the case, and at the time when you draft the plaint or the written statement, let us say these facts were not within your knowledge. Please remember, if you want to add these particular points, in that case, what you have to do is you must file a petition under Order 6 Rule 17. That is what is called amendment of pleadings. Amendment of pleadings, that is Order 6, Rule 17. This, this particular provision was a merry-go-round for most of the civil advocates, where you file a petition not for the purpose of allowing the petition, getting the petition dismissed, and if you are aggrieved by that petition, you file a revision in the High Court, and then that gets on for some time. You apply for stay, you get a stay, and ultimately, the previous position was that amendment can be allowed at any stage, including at the stage of second appeal. But your wings have been cut now by the amendment of CPC in 2002, that is by introduction of a provision called Order 6, Rule 17, Subclause 2, which says amendment cannot be allowed as a matter of course once issues are framed and the evidence affidavits are filed into the court. Amendments can be allowed only as a last resort, and court has to give reasons why the amendment is to be allowed. But there are various rulings to say that subsequent events can always be taken into consideration, provided you show sufficient cause and sufficient reasons. And then, in that case, in exceptional cases alone, amendment can be allowed. That is Order 6, Rule 17, Subclause 2. This has been introduced by the Amending Act 22 of 2002, effective from 1/7/2002. So, Order 6, Rule 17, bracket 2 is a new provision which didn't exist earlier. Then we go to the pleadings in general. Order 7. Order 7 has to be read in conjunction with Section 26 CPC. First and foremost is, when I was dealing with definitions in the introductory class, Section 2 of the Civil Procedure Code is very, very important. It is called the interpretation clause. First and foremost is, after all, when a child is hungry, it alerts the mother, it cries and alerts the mother and says, please, I am hungry, please feed me. The same way, as far as a civil court is concerned, when you go to a civil court and you want to file a case against the opposite party, you must file a document called plaint. And plaint is normally filed under the provisions of Section 26, read with Order 7, Rule 1 and 2. Then we go further. Sir, what are the contents of a plaint? Here, contents of a plaint is, first and foremost is name of the court. I told you that we have two types of courts. One is called the higher judiciary and another is called the subordinate judiciary. All suits of civil nature have to be filed in subordinate courts. Our High Court or the Andhra High Court has no original jurisdiction. Only the presidency courts like Kolkata, Mumbai, and Chennai have got original jurisdiction. You can't file a civil suit in the High Court. All civil suits will have to be filed in the civil court alone. Then first is name of the court. In the court of so and so, junior civil judge or senior civil judge or district judge or chief judge or whatever it is. Then I told you all suits on the civil side are numbered as OS. OS means suit on the original side is what is called OS of whichever year it may be. Then the next particular which you have to mention in a plaint is between. Please remember, like a contract, you cannot fight within yourself. There must be opposite party against whom you must initiate action. Then the person who initiates action in a civil court throws the ball into the civil court and files a pleading called the plaint is called the plaintiff, or in Telugu is called the Vadi. And name, his full description, age, then occupation, and then his address will have to be clearly mentioned. And you call him as a plaintiff. I'm only saying if it's a single individual. Suppose different plaintiffs are there, you must give the name, address, and description of the various plaintiffs. Then and or versus, you may write anything, so and so. That is the names of the defendants. That is his name, son of, age, occupation, resident of. Then if there are more than one defendant, the description of all of them, they are all collectively called defendants or co-defendants, as you may call it, or prativadi or prativadulu. And the pleading which you filed into the court in the form of a plaint is called a dawa or arzi, or it is called manuvu. Manuvu is also used in Telugu. Then you say on what provision you file the plaint. The next title should be plaint under section 26, read with order 7, rule 1 and 2 CPC. Then now you got various enactments, sir, like Contracts Act, the Specific Relief Act, Partnership Act, Transfer of Property Act, Easements Act. Then you got so many enactments are there. Under which enactment you are filing the suit, and which enactment and which provision of that particular enactment the suit is filed. That is the next title. Then suppose it's a money suit, then you say suit for recovery of money of rupees so and so under the promissory note and receipt, or suit based on bond, or suit based on what is called suit for whatever money it may be. It may be on an agreement, it can be on a bond, it can be on the basis of a check, so on and so forth. That particulars, that title you give. Then we come to the next clause, what is called name, address, and description of the plaintiff or plaintiffs, as you may call it. Then names, addresses, and description of the defendants. The full description has to be given. Then next one is we come to the third clause. Since if you are the advocate for the party, you say the address for service of all summons and notices on the plaintiff or plaintiffs is that of their counsel, so and so, with email number and your cell number and your address where you are having your office. Next one is the address for service of all summons and notices on the defendants is the same as given above. Given above means in the description part of it, what you give is the same you have to mention. Then we come to an important clause called brief facts of the case. Here again, I tell you that you have to follow the American system of study where you go for short paragraphs. Suppose you go to para 4A, para 4B, para 4C, 4D, 4E, like that, you go like that. Then you say that on so and so date, the defendant borrowed and received from the plaintiff a sum of rupees so and executed a promissory note and receipt in proof of having received the money, and also issued a post-dated check bearing number so and so on so and so bank dated so and the check when presented for payment was returned bounced with endorsement referred to drawer. The original promissory note and receipt along with the returned check and bank memo are filed and marked as documents 1 to 4. Then we come to the next paragraph. In spite of several demands and requests, the defendant has not paid the money, and hence the plaintiff issued a legal notice dated so and so to the defendant or defendants, as you may call it, calling upon him or them to pay the suit amount. The defendant received the notice but did not send any reply nor paid any amount. The office copy of the legal notice along with the postal acknowledgements are filed and marked so and so. Then we come to the next clause. The plaintiff claims a sum of rupees so and so from so and so date to so and so date as follows. Actual amount due, interest on rupees so and so from so and so to so and so at 24% per annum equal to so and so. 3 is notice charges. Then you add up all of them and then come to a particular figure saying this is the total. Then we come to the most important clause called cause of action. Yesterday, I also defined what cause of action means. The various causes, various reasons which has given rise to an action in a court of law. That is, it's a cumulative combination of facts and documents which gives rise to an action in a court of law is what is called cause of action. Then we say on what date the promissory note is executed, what day the check has been given, what day the check has got bounced, and what are the steps you have taken to recover that money that you incorporate in the cause of action paragraph. Then next we come to what is called court fees. Please remember, sometimes they say, దేవుడు వరం ఇచ్చిన పూజారి అడ్డొచ్చాడంట. So the government also has to get its share of revenue. That's the reason why we have the Court Fees Act in every state. Here the suit is valued for the purpose of court fee and jurisdiction at rupees so and so, and a court fee of rupees dash is paid under that relevant section of the Court Fees Act. Then here one thing I come to the next type of suit. Then after that, we come to the jurisdiction part of it. We said this honorable court has jurisdiction to try the suit as the parties reside and work for gain at Secunderabad within the jurisdiction of this court, or the suit scheduled property is located within the jurisdiction of this court at Bonpalli or whatever it is you may call it. That gives the right of the court to entertain your matter. Then one more important thing is you must also write a clause about limitation. How you say that the suit is within time and within the period of limitation. That means that paragraph has to be added. Then we come to declaration. We say that we have not, the plaintiff states that he has not filed any suit in respect of the same claim, nor any suit is pending in respect of the same cause of action. Then we come to the next one called the most important clause called prayer. The plaintiff therefore prays, plaintiff or plaintiffs as you may call it, therefore prays for a judgment and decree against the defendant, or if there are more than one defendant, defendants, for recovery of rupees so and so, together with cost and interest at 24% per annum from date of the document, that is whatever document it may be, till the date of suit, and future interest at 24% per annum. Then B is, you say, cost of the suit. Then one more important thing is advocate has to protect himself, where that we take the verification. The, I so and so the plaintiff above name declare that the facts mentioned in para 1 to so and so till before the cause of action paragraph are true and correct, and facts mentioned in paras, that's from cause of action paragraph up to the prayer clause, are true to the best of my information, which I believe to be true after the contents. But since I'm acquainted with English, if I'm not acquainted with English, since I'm not acquainted with English, the print has been read over and explained to me in Telugu, which I understand. Then after that, the party signs, and also also says verified at whichever place it may be, Hyderabad or Secunderabad or Malkajgiri or whatever it is. Then we come to list of documents which you file along with the plate. Serial wise in a consecutive manner, you say 1, 2, 3, 4, 5, 6 or whatever it is. Then the party signs, and then the counsel also signs, that the advocate also signs, puts the date and also the place at which the plaint has been drafted or it's going to be filed. Then important thing in a plaint is docket is very important. First you give the name of the court, suit number, that is OS number of whichever year it may be, between so and so plaintiff and the so and so defendant. Then plaint filed under order 7 section 26 right with order 7 rule 1 and 2 CPC, then filed on whatever date it may be. Then address for service, you as the advocate filed by so and so, then you give your address or you put your rubber stamp there. This is how a plaint in a money suit is drafted. Then if you want me to translate into Telugu, I'll come to it straight. That is, కోర్టుల మనువు పెట్టే ముందు ఏదైతే మనం గమనించాలి, ఫస్ట్ ఇస్ ఆ కోర్టు ఏదైతే న్యాయస్థానం ఉందో దాని పర్టికులర్స్ ఇవ్వాలన్నమాట. తర్వాత ఏదైతే మనం కోర్టులో కేసు వేస్తున్నామో అది ఒరిజినల్ సూట్ అంటారు, ఓఎస్ నంబర్ అంటారు. ఏ సంవత్సరంలో అది మీరు రాయాలి, అది మీరు ఫిలప్ చేయని అక్కడ కోర్టు ఒక నంబర్ ఇస్తారు. దెన్ బిట్వీన్ అంటే ఎవరి మీద వేస్తున్నారని, ఎవరైతే వాది ఉన్నాడో వాడి పేరు, వాడి పూర్తి డిస్క్రిప్షన్, వాడి పూర్తి ఫాదర్స్ నేము, ఏజ్, వాడి ఏం వ్యక్తి, ఎక్కడ ఉంటాడో అది వాడి ప్లేంటిఫ్. దెన్ డిఫెండెంట్ అంటే ప్రతివాది అడ్రస్, వాడి పేరు, వాడి తండ్రి పేరు, దెన్ ఎక్కడ ఉంటాడో అది రాస్తారు, అది వాడి ప్రతివాది. దెన్ ఏదైతే మీరు మనువు కోర్టులో వేస్తారో అన్ని దావాలు ఆర్ అన్ని ఏమంటారు అర్జీలు కోర్టుల, అది మీరు plaint ప్లెయింట్ అండర్ సెక్షన్ అంటే దావా ఏదైతే ఉందో 26వ సెక్షన్ తర్వాత ఆర్డర్ 7 అని ఉంది. దాని ప్రకారం 1 అండ్ 2 సిపిసి అని చెప్పి మీరు ఒక హెడ్డింగ్ ఇస్తారు. తర్వాత ఏ చట్ట ప్రకారం మీరు వేస్తున్నారు ఏ ఎస్ సార్ ఇంగ్లీష్ ఓకే సరే. సో దిస్ ఈస్ హౌ ఎ ప్లెయింట్ ఇన్ ఎ మనీ సూట్ ఇస్ డ్రాఫ్టెడ్ సార్. దెన్ we come to how a suit in a how a suit for eviction is drafted. That is, we have got two types of suits in eviction matters. One is which is governed by the statutory law, and another is what is called by the contractual law. What do you mean by statutory law? Every state has got an enactment called the Rent Control Act or the Buildings Lease Rent Eviction Control Act. As far as our Telangana is concerned, we have got the Andhra Pradesh Lease Rent and Eviction Control Act of 1960. What does it say, sir? It says all buildings where the rent is less than 3,500 rupees or where the construction is beyond 15 years, only the rent controller can try that matter, and it's a separate tribunal constituted for deciding all rent control matters. And beyond 15 years or beyond 3,500 rent, as far as municipal area is concerned, it is governed by the general law, that is governed by the law of leases as embodied in transfer of property act. Then here in in rent control matters, how do you write, sir? In the court of the principal rent controller, Secunderabad or Hyderabad, whatever the case may be, all cases under the Rent Control Act are numbered as RC. RC means rent control case. In Karnataka, Chennai, and all, they are called RCC, rent control case. But here in Telangana and Andhra, they call it as RC. RC means rent control case, rent case of whichever year it may be, between so and so and so and so. The person who files the eviction petition is called the petitioner, and the person against whom the petition is filed is called the respondent, or who has to respond to the claim that is made by the landlord or a claim that is made by the petitioner. And there is a section for eviction. If you want to proceed under the Rent Control Act, Section 10 is there, which gives you the various grounds: default, subletting, the next one is nuisance, and then using the premises not in a neat and habitable condition, the tenant having alternate accommodation, the landlord requires it for personal occupation, or he requires it for additional accommodation, so on and so forth. That is embodied in Section 10. You cannot file a rent control case unless and until you come under some of the provisions of Order 10. I'm sorry, Section 10, rather. Sorry. Here, same thing: name, address, and description. Name, address, and description of the parties. Then you say, then we come across address for service, then brief facts of the case, whatever, how the tenant has defaulted, how he has violated the terms of tenancy, everything is stated. And then you say that you have given a notice is not necessary in rent control matters, but you say, in spite of several demands and requests, the respondent has not vacated the tenanted premises, and hence I am constrained to file this eviction petition. And the court fee which you pay under the rent control in a rent control case is hardly 2 rupees. It is paid under 10(9) schedule 2 of the Court Fees Act. And then you say how this court has got jurisdiction. Then after that you go to what is called no other case is filed, and then last one is paid. The petitioner therefore pays for a judgment and decree against the respondent and all persons holding possession through or under him to vacate and deliver vacant possession of the premises number so and so situated at so and so, so and so. Then you give petitioner signs, the council also signs, the petitioner verifies that the facts mentioned above is true and correct, and he signs, and then place where it is verified is also mentioned. Then we say what are the documents you file along with the petition. You mention it as list of documents filed along with the petition. And then the most important thing in a rent control matter is schedule of property. Just like you describe yourself as so and so, son of so and so, age so and so, occupation so and so, resident of so and so, a property also has got a proper description. You say all that piece and parcel of plot number so and so, in house number so and so, admeasuring so and so square yards, situated at so and so, bounded on the north by so and so, south by so and so, east by so and so, and west by so and so. And the party also has to give the schedule and verify that the schedule mentioned above is true and correct. Please remember one thing, you have to bear it in mind. You must give the correct description and the correct boundaries. If you don't give the correct description and correct boundaries, you will suffer tomorrow. Even if you succeed, you cannot get rid of the tenant. This is our rent control. First is for eviction. Then we have got fair rent. Fair rent means, suppose let us the tenant is only paying peanuts of 250 rupees, but today if it's let out, it can easily fetch 10,000 or 15,000 rupees. Then you say in the vicinity, it is the rent prevailing, let the rent be fixed at so and so figure. Then the court, after inquiry, finds that the rent has to be enhanced. The court has got the power under Section 4 of the Rent Control Act to enhance the rent and fix the fair rent. Then we go to Section 8. Suppose the tenant sends the rent by money order. It is refused by the landlord, or the landlord refuses to receive the rent. The tenant can give a notice to the landlord. Please specify your bank account number, or so that I can deposit the money. Suppose the landlord does not give the bank account number, you can always file an RC under under Section 8, asking the court to give you permission to deposit the rents into court, and then the court, after issuing notice, permits you to deposit the rents into court. That's how you get rid of what is called default clause. Then you go to Section 10, I've already discussed, that is eviction. Then Section 12, suppose a building is in a dilapidated condition, you want to demolish it and then reconstruct it. You can always file a petition before the Rent Control Court stating various reasons. But one thing is this, you must give an undertaking that as soon as the building is constructed, you shall re-let out the property to the same tenant subject to the payment of rent, whichever rent is fixed. Then we go to Section 14, that is what is called amenities. Suppose, please remember, everyone requires certain things in our day-to-day life: light, air, sanitation, ventilation, so on and so forth. In case the landlord cuts off the electricity or cuts off the water supply, in order to compel you to vacate the premises, you can always file a petition under Section 14 of the Rent Control Act for restoration of the amenities which you are enjoying it either to. Then you have got one more provision called Section 20. Whenever you are aggrieved by an order passed by the rent controller, you have got a right of appeal which you can file it before the appellate court wherever it is located. And then you can also ask for stay of execution and say, still the appeal is disposed of, I should not be evicted from the property. But one thing you must remember in mind is, when you file an appeal, you must file all the rent receipts and then say, sir, I'm not a defaulter, but still the eviction order has been passed against you. Then what the appellate court does is, it calls for the record, and then it has got a right of setting aside, cancelling, confirming, or varying or modifying the order of the lower court. Then suppose even then you are aggrieved by the appellate court's order, you can go by way of revision before the High Court under Section 22 of the Rent Control Act. These are all the various provisions. Why I'm trying to tell you all that is, this is only the statutory law. But here, one thing you must remember is, the defense for a tenant in a rent control matter is much greater than what is in general law. What? Because of why? Because suppose the tenant belongs to an essential service, he is under the service of the central government or the state government, he cannot be evicted from the property under the ground of self-occupation. Only exception being, suppose the landlord also is in essential service, the claim of the landlord has got uh, precedence over the claim of the tenant. Then one more defense that is open to a tenant in a rent control matter is, suppose the landlord has got various buildings, but still he wants to get you evicted. But unfortunately, what is happening is, our judgments in our High Court, that is Telangana High Court or either to the Andhra Pradesh High Court, was mostly in favor of landlords. Why? Because there's one of the judgments of Justice Ramchandra Raju who says, so long as the right to property is recognized, it is for the landlord to choose whichever property he likes. He can choose any property and say, though I have other buildings, I want only this building. That's what are various judgments. Why? Because these judges also suffered in the hands of tenants. Then we go to the contractual law. I think most of some of you have worked as on the labor side know that you cannot compel an unwilling master to keep a person in employment over whom he has lost confidence. When a general law is when the rent is more than 3,500 rupees in municipal area, and in corporations when it's more than 2,500, you have to only go by general law, that is under the Transfer of Property Act, section 105 to 114 of the Transfer of Property Act deals with leases. When I come to the TP Act, I shall discuss it in detail. The same things have to be mentioned, but one thing you must remember is quit notice has to be given. That is, quit notice means suppose the tenancy is from first to the end of the month, you have to give a notice. At least a 2 weeks prior notice has to be given, asking the tenant to vacate by the end of his monthly tenancy and hand over possession to you on the next day. If he does not do it, then in that case you can always file a civil suit. Please bear one thing in mind: better to give a lengthy period so that we know, because the tenants manage the postman to see that the notice is returned with some endorsement or the other. Then here, when we draft a suit under the TP Act, you must also ask for eviction, possession. You must also ask for arrears of rent, and you must also ask for mean profits. I'll tell you what mean profits mean. Mean profits means suppose I'm paying today I'm paying 10,000 rupees as rent, but the same accommodation, same facilities, and same location. If I'm let out, the neighbor is paying about 25,000 rupees. That 25, the excess of 15,000 which is paid, I can claim as damages from the tenant by saying this is what is called mean profits. And mean profits are normally paid after the notice period has expired. But till the notice period, you've got a right of claiming the rent. Then tenancy is of three types. One is called tenant holding over, tenant by will, and tenant by sufferance. Tenant holding over means a tenant who is in occupation of the property even after the expiry of the lease is called a tenant holding over. Tenant at will means where there is no period fixed. At any time when I ask possession, the tenant has to vacate and hand over possession to me. And tenant by sufferance means where I've given a notice of termination, tenant still continues in occupation. He is called a tenant by sufferance. I will not go into that aspect. But the question is, then the question arises, sir, how a plaint has to be drafted. Same thing like a rent control matter, only difference is the person who files the suit is called a plaintiff, and the person against whom it is filed is called the defendant. Then we go to the third type of suit. Suppose you file a suit for specific performance, how the plaint has to be drafted. Same particulars you mentioned, but you also say in one paragraph that on so and so date, the defendant executed an agreement of sale in respect of so and so property, agreeing to sell the property for a particular consideration, and a sum of rupees so and so was paid as advance, and an agreement of sale was executed by the defendant in favor of the plaintiff. The original agreement is filed and marked so and so. Then we say on so and so date, the plaintiff issued a notice dated so and so, calling upon the defendant to execute and register the sale deed. The defendant received the notice but did not send any reply. Then we say the cause of action, jurisdiction, so on and so forth. Same thing I have to write. But one thing is this: whatever arrears are due on the date of suit, that is before the expiry of the lease, it is called arrears of rent that you have to join. And after the expiry of the notice, what you claim as damages, which are called mean profits, that you should also value. Then, when the valuation paragraph, you have to value the suit as per the annual rental value of the property. And next one is arrears of rent, you have to separately value. Then mean profits, proportionate mean profits up to the date of suit, you will have to value and pay the necessary court fee under the relevant provision of the Court Fees Act. Then jurisdiction part of it, you say how the court has got jurisdiction, then declaration, so on, limited, so on and so forth, and then the prayer. Then the prayer clause, it is better you subdivide the various reliefs for eviction and possession of premises number so and so by directing the defendant and all persons holding possession through or under him to vacate and deliver vacant possession. For arrears of rent of rupees so and so from so and so period to so and so period, for proportionate mean profits from so and so to so and so period, and fourth one is future mean profits at rupees so and so from the date of decree till the date of realization, so on and so forth. And then you mentioned the schedule of property, that is very, very important, and the schedule has to be verified by the party. So these are the various aspects. These are some of the aspects in which the suits are filed. They are not exhaustive, but they are brief. Now, another type of play, I think this will do. When I come to the TP Act, again, I'll repeat these particular provisions, how they are drafted. In Order 7, you've got one important provision called receiving documents. Along with the suit, you don't file certain documents. But subsequently, you want to introduce some documents. Then, in that case, if you are the plaintiff, you file the petition under Order 7, Rule 14, bracket 2. Order 7, Rule 14, bracket 2. It is filed in the form of an interlocutory application or what is called a miscellaneous application, a petition accompanied by an affidavit stating the various facts, what are the documents that have been filed, and then that is filed into the court receives it. Earlier, we had a provision called Order 13, Rule 2. Whenever any document is filed after the suit is instituted, they were filed under Order 13, Rule 2 under the old code. But now Order 13, Rule 2 has no application. After the amendment of CPC in 2002, you have to file it under Order 7, Rule 14, bracket 2. Then a copy of the documents, you will have to furnish it to the opposite side. Without furnishing it, you cannot get it allowed or admitted. Then we go to rejection and return of plaint. But I think with this we'll stop, and then I'll come to the important rules of civil rules of practice. Here, what do you mean by return of plaint? Suppose the suit is filed in a court which has no right to entertain the matter, the court has no other option than returning your plaint for presentation before proper court. Return of plaint means where that particular court has no authority to try your matter or entertain your matter on the ground of jurisdiction, it returns your plaint. Then, what do you mean by rejection? Suppose in the plaint you don't mention you don't pay the court fee, then you don't pay the court fee even if it's called upon, then you don't mention the cause of action, or your suit is barred by any law for the time being in force. In those four cases, your plaint which you have filed into the court can be rejected by the court, and you cannot file a fresh plaint on the same cause of action. That is called rejection of plaint. I think we have covered plaint, and to the next lecture, I will cover the written statement, counterclaim, and set off. Here, as far as because I want to go at a slower pace, because all of us do not possess the same IQ or the same assimilation qualities. So that is the reason I'm going a bit slow. I can finish the lecture even in 1 day or 2 days. That is not the criteria. It should enter your brains. You must have clear ideas, and any doubts you have got, any questions you can always ask and get it clear. Tomorrow we'll be discussing about written statement, set off, and counterclaim. Okay. So, as far as rejection of plaint is concerned, it is said now it has become a fashion now. That is, whenever a plaint is filed into the court, next day rejection of the plaint petition is filed. But this has been said to not now by the judgment of the division bench of Justice Shamim Akhtar and Apparao, who says that was reported in 2021 ALT, I think it is 177 or so, where they say a suit cannot be thrown out at the threshold unless and until a full trial takes place. Parties are given an opportunity of leading their own evidences. Issues are framed on that, and then only the plaint can be rejected, not at the threshold. That is a famous judgment of our division bench of Justice Shamim Akhtar and Apparao. So, you cannot throw out a plaint just like that at the stage when the suit is filed. Then the second aspect is when a plaint cannot be thrown out. Suppose during the pendency of the suit, let us say the other side, one of the parties dies, and an LR petition is filed, or what is called legal representative petition is filed, court without disposing of the LR petition, without issuing notice to the proposed LR, allows the rejection, then in that case, High Court can always set it aside because it's an irregularity that is committed. In all cases, the plaint cannot be rejected. Suppose the plaint does not disclose the cause of action, or the court fee that is paid is not sufficient court fee, or you have been asked to pay extra court fee which you have not paid. Or next one is when it is barred by any law for the time being in force. In those cases, a complete trial need not take place. A suit can be thrown out at the threshold itself. But the various judgment says that a suit cannot be thrown out at the threshold. Issue has to be framed and it has to be decided, and then only a plaint can be rejected. Then, return of the plaint. When the court has no jurisdiction, when the particular point raised by you is not within the purview of the court, or that particular claim is not maintainable in that particular court. For example, now we are in the era of tribunals. For example, you've got the Cooperative Societies Act, house, then you've got the labor laws like Industrial Disputes Act, Trade Unions Act, then you've got what is called arbitration and conciliation matters. All these matters, civil court has no jurisdiction. You have to go before the proper court. Then in that case, if you file a plaint, court returns it and then asks you to present it in the proper court. Then sometimes one thing is that here, normally in money suits, it is normally filed before the last day because no person files a suit immediately. On the last day, it may be a bank, it may be a financial institution, it may be a private individual also. What is it? Your duty as an advocate? Your duty as an advocate is to file it into the court. Maybe it may be returned, but it is every scrap of paper that is filed into the court, including the stamp that is affixed, is entered in a book called the suit register. It is popularly called the SR register or suit register, and then it gets an accession number. It means a suit has been filed on a proper in a proper way within time, and then it may be returned because some objections are there. It is your duty to take back the return of the bundle and then represent it after compliance of the office objections. Sometimes, let us say, instead of filing in a superior court, you have filed it in the lower court. The court returns the plaint, gives you time of 14 days. Then what is your duty, sir? Take return of the bundle, go to the superior court, then change the cost tag, change the name of the court, and then file it before that court within the time that is granted. Why? Because as far as filing it on the last day also, your matter being entered in a register called the suit register, it means ipso facto it proves it is filed within time. So, in cases where the courts have no jurisdiction, in case the court cannot decide a particular matter on that particular aspect, then if some other authority has got a right, then in that case the plaint is returned for proper presentation. Or suppose let us say on the civil rules of practice, you have to stitch the plaint and then file it into the court. Or let us say the party does not sign the plaint properly, you do not sign it. There are blanks left in the plaint. Then the court returns it for compliance of office objections. Return doesn't mean rejection. Return is something different. Rejection is something different. Return means you can always take return of the bundle, comply with the objections, resubmit it, and then it will be taken. But rejection means once it is removed, once the court does not accept it, it throws you out. Then in that case, you cannot file a fresh suit based on the same cause of action. I think with this, as far as plaint is concerned, these are the basic factors which have to be kept in mind. And then we go to order 8, the various aspects of order 8. That is, in order 8, you've got the set off counterclaim and also alternate pleadings. And then you've got rejoinder, so on and so forth, which we will discuss tomorrow. Any questions, please?
Any questions, please? Or else we will conclude the class. Any questions from your end, or otherwise we'll conclude the class. Madam, Krish, Naveen Kumar.
Possibility.
నవీన్ కుమార్ పసుపులేటి గారిని అన్మ్యూట్ చేయండి, క్రిష్ గారిని అన్మ్యూట్ చేయండి.
Sir,
Yes.
sir, I have three questions, sir.
Yes.
Sir, one is
Go one by one,
saying
please. Go one by one.
Yes, sir. Sure, sir.
Yes.
One after one, I tell you,
Yeah.
sir. Sir, in an apartment association flat space,
Yes.
the former president he misused the funds, sir.
Right.
So, can I file this case under recovery of money suit or arbitration and conciliation court?
Yeah. You have to go only under the Arbitration and Conciliation Act, because now the Consumer Court also cannot entertain your matter because of the latest judgment, sir.
So, why not recover the money suit, sir? Because I want to recover the money.
If you want to recover the money, go by money suit under the Arbitration and Conciliation Act.
Is it valid, sir?
Definitely valid.
In civil court, it's not valid, sir.
No, sir. No, civil court cannot entertain.
So the second one, sir.
నవీన్ గారు
Yeah.
one second. There's
Okay, sure, sir.
another person, Mr. Krish.
Sure, sir.
Mr. Krish,
Yes, yes.
please go ahead with your question.
Sir, order 7,
Yeah.
rule 11, rejection of claim.
Rejection order 7, rule 10 and 11.
Rule 11, rejection of claim.
Yes.
As you stated, one judgment, sir, that is Justice Rahim Akhtar and Appar.
Yeah, Appar.
2020.
Yeah. Yeah.
Could you elaborate the judgments?
Yes, sir. That case arose when a petition was filed before the lower court for rejecting a plea, saying that it does not comply with certain basic requirements. Then, when the matter
Manchala
Manchala,
Ravindra garu, please mute yourself. Ravindranath garu, Janagam.
Sir, good evening, sir.
సార్ కొంచెం మ్యూట్ లో పెట్టండి సార్, కొంచెం మ్యూట్ లో పెట్టండి. వాళ్ళు క్వశ్చన్ అడిగారు, వాళ్ళు ఆన్సర్ చేసి మీకు క్వశ్చన్ అడుగుతారు.
just wait, sir.
క్రిష్ గారు గో హెడ్.
Sir, judgment కొంచెం elaborate చేయండి, sir.
That case, what happened was a suit was filed before the lower court and the petition was filed for rejection of the plea. And then once the petition was filed, it was allowed. Then against that, the person who was aggrieved by that went to the High Court and questioned the judgment of the lower court. Then the High Court, while deciding it, said, in all matters, a case cannot be thrown out at the threshold if really the plaint is not maintainable. It is incumbent on the part of the court to frame an issue, decide it later when the evidences are read. Only at that stage a finding can be given. At the initial stage, the suit cannot be, a plaint cannot be thrown out. That is the judgment of the High Court, sir.
Sir, that means rejection of claim. ఒకసారి కేసు ఫైల్ చేసిన తర్వాత ఇమీడియట్ గా రిజెక్షన్ ఆఫ్ క్లెయిమ్ వెయ్యాలి, కానీ అట్ ది మిడ్ ఆఫ్ ది ట్రయల్ లో కానీ తర్వాత కానీ వేయకూడదు సార్.
ఎప్పుడైనా వేయొచ్చండి, బట్ వాట్ ది హై కోర్ట్ హస్ సెడ్ ఇన్ ద బెంచ్ జడ్జ్మెంట్ ఇస్ యూ కెనాట్ జస్ట్ త్రో అవే ఎ ప్లేంట్ అట్ ది ఇనిషియల్ స్టేజ్ ఇట్ సెల్ఫ్. You can frame an issue, try that issue. If you are satisfied the plaint is not maintainable, then throw it out, not immediately. That's what the bench judgment says.
Thank you, sir. Thank you, sir.
Welcome.
Naveen Kumar Pasupuletti garu, you can go ahead with the second question.
Sir, in the earlier case, I told the apartment case in arbitration and conciliation court, but the civil case was accepted that application, sir. So can I challenge that application?
You can challenge it by way of filing a writ in the High Court, sir.
Okay, sir. Sir, second one, yesterday about unregistered document I asked, sir.
Yes.
But I not wrote the notes. Can you again repeat that one, sir?
As far as an unregistered document is concerned, it can be validated by the registrar. But now they say registrar is washing off their hands by saying, you please get it impounded, let the court send it. Then we will decide the matter of validate it.
Okay. So
But it does not. But it does not cure the effect of registration. If it's not registered only for the stamp duty, it can be decided, and for a collateral purpose only, it can be decided, not for a primary purpose.
Okay, sir.
Yes.
One second. Anybody else have a doubt? Please raise your hand so that he can answer your questions. I hope
Sir,
everybody is following
question,
up.
sir.
Yes, who's there? Please tell out your name.
I mean,
Naveen,
doubt, sir. That is
Naveen Kumar,
Yeah.
first litigator.
Chepandi.
Sir, the property is in the name of the husband's mother, that is mother-in-law.
Right.
So the the husband he was absconded due to his mental disorder.
Right.
So now the wife and the wife sons, children, are they entitled to claim the property which is in the name of the mother-in-law? Mother-in-law have only one daughter, one son.
Right. They'll have to go.
So how
by,
can I proceed for your suggestion?
they can take a certificate from the mental hospital saying that the
But
person
he's not there.
absconded.
He's absconded.
No, sir. So long as he is not traced, they cannot ask because he has got the first right, sir.
Above 7 years.
7 years means that under 107 of the Evidence Act, a suit has to be filed saying that is legally dead. Because any person who is not found for 7 years is presumed to be legally dead.
So can we claim the property on
You
the
can
name
claim
of
it only after obtaining a decree from the court saying that is legally dead. That is under 107 Evidence Act.
The nature of the property is mother's self-acquired property. Mother-in-law self-acquired
That
property.
is under Section 14. She is the absolute owner of the property. Section 4, Hindu Succession Act.
Succession.
Yes.
Santosh, you have any doubt? Santosh, do you have any doubt? Santosh, yes, sir. Okay. Anybody else?
Yeah. Hello. Am I audible? This is
Yes,
Uday.
you are audible, Uday. Please go ahead.
Yeah. Sir, very good afternoon. Sir, one small question. In the apartment, while purchasing, builder is collected to provide the drinking water, 50,000 rupees from each apartment owner.
Right.
He kept that 50,000 with him without applying the water connection.
Right.
After 2 years,
Yeah.
he said that after occupancy certificate, the water connection will come after 3 months once
Right.
we receive the occupancy certificate.
Right.
But after occupancy certificate came after 3 months,
Yeah.
simply without informing, he refunded the amount
Right.
without providing the water connection.
Right.
So on this, how we can proceed against it?
See, now the latest trend in Consumer Act is normally you said you must say that you are a consumer, and the builder is a person providing services. There was deficiency of service which he has not kept up. That is water supply. But earlier they used to entertain matters. Now the Consumer Act has been amended, whereby they say Consumer Court will have no jurisdiction in these matters. You will have to go only by civil law.
Shall we, like a RERA, sir?
You can do so. You can do so. Because
So
earlier we didn't have the RERA. Now you got the RERA itself.
So shall we make 420 on this?
You file a criminal complaint. You can file it under 406 and 420.
406 and
Yeah.
Sir, in apartment case earlier said, no, sir, in the misuse of the money, who will become the locus standi, sir?
The developer, sir.
No, sir, in apartment owners, not
Yeah.
developers. The flat owner association.
Misappropriation is there. Whoever comes into the where the funds come into someone's hands, that person who is holding the funds becomes liable, sir.
Who can write to appear before the court?
Then you
The
have
next president?
you are president and secretary. Right.
Anybody else? Shall we conclude it?
Sir, Order 6 and Rule 4, please.
That is Order 6, Rule 4 is if the plaint is vague, imaginary, not clear, which does not enter the brains of a defendant who has to prepare the written statement, or the documents are not clear, not very, very clear, then in that case you can get that clarity from the other side by putting it in the form of questionnaire and then ask him to provide those documents through which he can prepare his defense. That is what is called Order 6, Rule 4, petition for better particulars.
Thank you, sir.
Welcome.
All right, we are concluding the class as of now. Any more questions you have? Please reserve your questions for tomorrow, and we will come back you tomorrow. And the third class of CPC, we continue it. All right. Thank you.
Thank you.
Thank you, one and all.
Thank you, one and all.
Thank you, sir.
Thank you.
Welcome.
There's no point in rushing to. ఏమంటారు? There's no point in rushing towards